Court-martial bloopers part 9. Okay, this one relates to a case that was also out of Cavazos, also formerly known as Fort Hood. Our office was really substantial in having several of its litigators who were very happy to defend cases that otherwise would ordinarily be resolved by a guilty plea. Maybe a drug case, maybe failure to repair, like napping in the right place at the right time, disrespect, disobey. Like a lot of times that stuff seems pretty clear cut. And so a lot of people plead it out. Well, there's also many valid reasons why not to plead it out. Even if the evidence, quote, is clear and it's a, quote, straightforward case, or insert whatever the government counsel tries to argue. The biggest reason is because there's just not a meeting of the minds in terms of what the case is worth, right? So sometimes you're walking to an ambush, like you know that you're in all likelihood gonna lose. You can also just kind of sit there and wait for the government to trip on its feet. Well, in this case, out of Cavazos, out of formerly known as Fort Hood, one of my fellow counsel in the struggle took a case forward and defended it on a contested AWOL case. I think he had like 4 or 5 AWOLs, a couple of disrespects, and maybe a couple of disobeys. It was kind of like a hodgepodge. And it may have even been an Article 15 turn down. Anyway, they're at trial, they're contesting it. During his closing argument, the defense attorney referred to his client. So we always tell people, don't call people the accused, don't call people my client, like they have a name, you want to personalize them when you're the defense attorney. And he called his client Sergeant AWOL, which is kind of fitting. And the panel started laughing. I think there was sort of a general agreement that he really was Sergeant AWOL, messy military lawyer.